Great. Good afternoon, everyone, once again. We move now to a topic on which we could spend the entirety of the rest of the conference. That is national security in global economic regulation. A number of us have been following this topic closely, and we're fortunate to have with us here on the stage a collection of experts who will address the topic today. We are also cognizant of the fact that looking out into the auditorium, there is a wealth of experience and expertise also on the topic here, so we will be sure to allow time for a broader conversation with all of you in the second hour. But first, let me introduce those who are on the stage. You have their biographies in your tote bag, but not so for our viewers at home, so I will just let you know who they are. To my left, Henrique Moraes, career diplomat with the Brazilian Ministry of External Relations, currently at the mission of Brazil to the EU in Brussels, author of a variety of international trade law works. Next, Ted Posner, partner at Weil Gotshal in Washington, D.C., with extensive private practice and government experience that will inform today's discussion. Next, Victoria Lapa, PhD candidate at Bocconi University, previously a practitioner in the Ukraine and a visiting scholar at a variety of European international law institutions. Next, Barak Renda from the Turkish mission to the WTO. He'll supplement our discussion from the government perspective as things have been playing out here in Geneva and keeping him very busy. Next, Cindy Wang, assistant professor at Fujian Catholic University in Taiwan. Cindy's research on export control regimes will be critical to our understanding of how national security and international economic law intersect. And last but not least, Nicholas Lamp, who teaches at Queen's University in Canada, but is no stranger to this town, having previously worked as a lawyer at the appellate body here at the WTO down the street. So, as you can see from this distinguished group, we are well positioned to at least lay out the issues in this topic in the short time that we have. And so many issues there are. I can't imagine a better time to have this conversation. Our conversation comes at the height of the tariff tit-for-tat as the Trump administration uses exceptional delegations of authority to levy duties against trading partners. Our conversation comes on the heels of the adjudication of the national security exception in the WTO. We have new types of investment restrictions on foreign investments, evolving regulations on engagement with certain economic actors as economic sanctions change in scope and form. We have reform to frameworks governing exports and the increased use of emergency economic powers. Those are just the ones that make the headlines. It's a time when policymakers are facing critical questions, reconsidering the international legal and economic institutional design in light of security concerns. So let's dive right in. I want to ask Henrique to start us off thematically. Set the scene for us, if you will, Henrique. Clearly, we have a lot that we can discuss in this time together. What are some of the big themes that you're seeing as relevant to recent events? What's your take on geopolitics and national security in global economic relation, as the title of this panel suggests? Let me pass this to you.
Thanks, Kathleen, and thanks for the organizer for inviting me. I'd just like to start off by putting out a disclaimer that I'm speaking in my personal capacity and the views are not necessarily those of the government of Brazil. I think when we look at the increasing influence of geopolitics and global economic regulation, I think we can break it down into three parts. Why are we witnessing an increasing influence of geopolitics in global economic governance broadly? International economic law more specifically. How is this influence playing out? And thirdly, what are the possible implications going forward for the future of global economic governance? So let me start by the first point. Why are we witnessing now this increasing role of geopolitics and security considerations into economic regulation? I think one of the key drivers behind this, let's say, development is a perception that there's a clash of economic models that is not addressed by the existing rules. Of course, in particular and central to this perception is the sense that the Chinese model is not addressed or disciplined, let's say, by the rules as they stand. And this means that there is this perception that the Chinese the nature of the Chinese model, heavily reliant on the state, which is ubiquitous, is not addressed by the rules as they stand, but also by the utter scale of the Chinese economic presence. It's an economy of $13 trillion in GDP, which, of course, has massive systemic implications for the global economy. You should notice that I'm mentioning the perception that the Chinese model does not fit, or that the rules as they are does not accommodate or address the Chinese model. I'm deliberately not passing judgment on whether the Chinese model fits or is consistent with or not the rules as they stand. My point here is to put out there that key actors such as the US and the EU, they share this perception and they are reacting accordingly. And this dynamic of Chinese behavior plus the reaction of key actors risks reshaping global economic regulation going forward. And that's the point I want to address. Part of this perception is a certain sense of a disconnect that China has been seeking to join, let's say, the global network of interdependence in an asymmetric way, whereby it benefits from the openness of foreign markets without reciprocating in its domestic market. And this is a frequent complaint if you read reports by the American Chamber in China, the European Chamber in China, the official position papers of both the EU and the US governments and other governments as well, that there's no reciprocity, that they have opened their markets, for example, to Chinese investors, but American, European, and other investors do not find in the Chinese domestic market the same level of openness. And this, I think, is important because it injects an element of distrust in this globalized network of interdependence, for lack of a better word. And of course, this distrust in some measure is compounded by strategies such as Made in China 2025, where the intention to increase the Chinese, if not self-sufficiency, but self-reliance on some sectors, increases the doubts whether China really wants to integrate into the global economy or not. And again, I'll just highlight again that I'm transmitting what seems to be the perception of actors that are reacting accordingly to that. And I think all these facts, they highlight that the notion of interdependence that was until recently predominantly viewed as a force for good, let's say, a source of mutual gains, starts to show also its side as a vulnerability, as a source of vulnerability, if not everybody is equally engaged. So countries are starting to react, and by countries I mean the US, but also increasingly actors such as Europe. So that leads me to the second point. How is geopolitics playing out concretely and affecting global economic regulation? 3 points here. I think the first one is states are increasingly stepping in to influence or reshape areas that until now have, you would see market forces operating more or less freely. So the point that Richard Baldwin was making before of the unbundling and the spread of global supply chains, governments are trying to affect that. So if you look at the recent executive order by the US government, basically what they're trying to do is to have an influence on the design of global supply chains in some areas considered strategic. And that is the second point on how geopolitics is playing out. Security considerations are increasingly entering into economic policymaking. So in areas where until now decisions would be based on, if not exclusively, but predominantly on an economic rationale, now you start seeing security considerations being brought to the table. If you look at the area of investment, so I think we were all trained as lawyers that foreign investments should be welcomed with almost no restrictions or conditions. Well, now the talk is a bit different. And you see, well, Ted will address that in a minute, I think, the US reinforcing its domestic regulation for investment screening, the EU adopting for the first time its regional mechanism on investment screening, which signals that there's a perception that decisions on admitting foreign investments, they should also bring into account security considerations and not only or exclusively economic considerations. I think this possible change in mood, let's say, was captured very elegantly by The Economist a couple of weeks ago when they said in a very interesting report on the US-China war, trade war or tech war, when they said that all of a sudden it's not only about making money. Making money is not enough anymore, and that I think captures a lot of what's happening. Countries start to see whether there are vulnerabilities that are also brought to the fore by economic transactions. And finally, a corollary of having security considerations brought into economic policy making is that we witness an enlargement, a legitimate one, I would say, of the notion of national security. So what is legitimately considered national security is going through an expansion. And I think the Grindr case in the US, where a Chinese investor was, I don't know if the verb is mandated or determined or ordered to divest its stake in the gay dating app Grindr because of national security concern. It says a lot of the zeitgeist of where we are now. Now, of course, these actions and developments, I think they play out more pronouncedly, in a more pronounced manner in some sectors. And tech sector, of course, is an obvious example with the US administration trying to influence supply chains in the tech sector, semiconductors. And I think that's why it would be more appropriate to mention perhaps an increasing influence of geoeconomics than of geopolitics, because you're not talking about the traditional objectives of geopolitical rivalry. Rather, the focus is on questions such as who will lead the plumbing, for example, of the next stage of the globalization that Richard was mentioning. That's what is at stake. So you're talking about economic leadership, but using strategic considerations and tools. My third point is, what are the implications going forward? And given the time constraints, I'm going to leave this deliberately for the Q&A in case any of you want to further discuss. Thank you very much, Kathleen.
Thank you so much, Henrique, for that overview. Now we want to dig into some of the manifestations or contestations of the trends and themes that Henrique described. Let's start with trade law and trade institutions. There's a lot we could cover in that alone. So I'm going to turn to Barak next, who's working on these issues from the perspective of a WTO member, thinking about them as a very active trading partner, although of course he joins us in his personal capacity today. So Barak, reflecting on what Henrique has said, do you agree with his characterizations? Would you wish to supplement them? And on the basis of what you see at WTO, what would you share with us?
Thank you, Kathleen. Yes, I would agree with a lot of what has been said so far. With the national security exceptions and the invocation of national security for trade measures, we can look at it in two ways. One, from a global perspective, which we just heard, and I will just shortly add to that. Another would be the WTO-centric view, which would entail more of a legal perspective based on the WTO agreements and other acquis. The global view that we also see from Turkey in many ways, that there is a general trend of retreating from multilateralism. And obviously, the WTO is getting its fair share out of that dynamic. And it has impacted what is going on at the WTO, our negotiations, the trade negotiations, or the lack thereof. There are reasons for this. Rise of China is one of them. And whenever there's a rising power in any system, it pushes the system and generates some sort of imbalance, and then the system needs to balance itself. And the US responds, but the US role is important, and it should not be simplified just to the point that it's responding to China's rise. We could discuss that a bit further, but it has underlying currents of why it is behaving the way it does. Globalization and interdependence, we heard about that in a very long and amazing presentation. There was a lot of anti-globalist movements back in the 90s. I remember when I was at school. There's still anti-globalization push right now, but in different ways. With the arrival and advent of technology, a lot of populations feel that they're being left out or being left behind. Rise of populism all over the world in politics. Politicians need to respond to the expectations and the fears, or sometimes even play on them, of their general public. But that could be a real risk in the next periods, next years, because when politicians and leaders respond to public opinion with the short-term, gains, strategically, the system gets hurt in the long run, and that creates further problems for everyone, and it becomes a real problem, and there's a real risk for that. Role of technology. Everybody's talking about the technological revolution. I think we need to understand this better, what it means, what implications that it will have for the economies. And it's in the early stages. But there are different types of impact of the technological revolution. I was just going through some of my college stuff a couple of weeks ago, and I found this book called The Great Transformation by Karl Polanyi. Talked about the impact of the Industrial Revolution and how that was a big push for change in societies. I think I highly recommend it. It becomes very, very relevant today, especially in light of going through the technological revolution and the rise of information age. And the rise of information age with respect to spread of use of social media and other electronic stuff, that also feeds to the rise of populist rhetoric everywhere. So there are those different dynamics that are linked to one another. Sometimes one of them just gets to the forefront, sometimes others. But all these are considerations. Now, this is the global context. The WTO-centric view, I'm sure Victoria will be speaking to it more effectively than I could. But in light of these dynamics, countries become or tend to become more protectionist. Nationalism in rhetoric becomes more spread. And that also translates into policy. And it is up to a lot of leaders, but the government workers like us, to make sure that, does not happen. So we've got agreements here at the WTO, and use of national security exceptions is a landmark issue. And this, in light of the Ukraine-Russia case, in a way that it is historic. And there are two key questions there. And I could interpret that, and I'll just leave some room for Q&A session, what those key questions are and how countries like Turkey could respond, for instance. But in this whole thing, in a way, this discussion, use of national security exceptions, what that means, we're talking about the future of the WTO or the multilateral trading system as we know it. That question is inevitable. The key concern here is that we've got rules, and you want to maintain these rules, you want to preserve these rules to the benefit for everyone. For all the members of the WTO, which is 164 the last time I checked, pretty global. We only have one system. It's not as if we can just scrap this off and put in from the scratch another system. So we need to understand the value of that and build on that. And this is pretty much what is that we keep discussing at the WTO nowadays. Thank you.
Thanks so much, Barak. Let's get into that legal, concrete issue of Article 21 and national security exception. So, Victoria, having studied this very closely here as part of your PhD, tell us a little bit about the historical and textual confrontations, if you will, that led to the exception and what we can expect.
Thank you very much, Kathleen, for your questions, and thanks for organizers for inviting me to contribute to this discussion. And I think Burak perfectly set the scene for making the case for the security exception in the WTO. So basically, right, the national security has become kind of very widely used by the states for adopting measures which they deem necessary for the protection of the essential security interests. And I wanted to address just two legal points which are related to the GATT Article 21. And historically, we know that one of the main debates which was surrounding the GATT Article 21 was the matter of jurisdiction. So does the panel have a jurisdiction to review national security issues? And we know that historically, for example, the United States was always claiming that WTO should stay away from the national security issues. And, for example, they were trying to say that national security is non-justiciable. So basically, the United States was trying to transpose the political question doctrine which is present in the US constitutional law to the WTO law. However, since we got dispute settlement understanding rules, this issue has become clearer because we know that Article 1.1 and Article 1.2 of the dispute settlement understanding doesn't provide additional or special rules for national security, and also security exception is covered by the GATT agreement. And we know that the issue of jurisdiction and justiciability is connected to the specific wording of the security exception it considers necessary, which is different from the general exceptions under Article 20. And this it considers wording brings me to the second point. And the second point is that, yes, it considers provides more deference to states, so there is more discretion with regard to adoption of the national security measures, but the issue is actually, does it considers wording qualify, for example, essential security measures, or does it qualify as well the interpretation of emergency in international relations, or does it qualify and gives like a full deference to states with regard to the any action which it considers necessary? And we were left kind of in dark with regard to the interpretation of all these issues. And we know that during the negotiations of the ITO Charter, this question was raised, for example, by the representative of the Netherlands, who also deemed these issues to be very vague. And at that time, the representative of the United States reassured that, yes, there is a vague wording, but he said that actually we understand that states will invoke it in a good faith, and also that they will think about real essential security interests instead of putting any kind of protectionist measure under the national security. And here, we should say that at that time, the understanding was that atmosphere under the ITO and then later under the GATT will prevent states from interpreting it in an abusive way. But as it was already mentioned by Burak and Henrik, we see that the atmosphere has changed and the interpretation of the security exception has come before the panel. And we know that recently the panel report was out on the Russia-Ukraine dispute.
Let's get into that. Great segue. If you would, both Burak, Victoria, give us your views on the impact of DS-512, this Ukraine-Russia case. What's your take on it? What's the impact for future cases?
Yeah, so I will give just a couple of points with regard to the Russia-Ukraine panel report. And first, I wanted just briefly to say that yes, panel accepted its jurisdiction. And panel said that actually each measure which was adopted by Russia was justified by GATT Article 21, and there was a situation of emergency in international relations between Russia and Ukraine, which ironically basically was created by Russia. But I wanted to say that like apart from the overall decision of the panel, first I think that panel kind of erred with regards to the procedural issue. First, because we have to understand the operation of the exception. We understand that historically, like, and with regard, for example, the review of GATT Article 20, it was a two-steps review, because first the panel had to establish a breach of substantive obligation under the GATT or GATT's agreement, for example, MFN or national treatment, and with regard to the breach of the substantive obligation, the burden of proof lies on the claimant. But then the panel has to decide whether the respondent, which invokes the security exception, discharge its burden of proof with regard to justification, the breach under the GATT Article 21. And here we see that the panel actually deviated from this procedure of review, because the panel has stated that for this case, the situation of emergency in international relations justifies the different order. And the panel said that in this case, it's not actually necessary to review the breach of the substantive obligation, and they went directly to review the justification under the GATT Article 21. And I think in this case also, the panel discharged the burden of proof on behalf of Russia, because Russia was claiming that the panel has no jurisdiction. As with regard to the standard of review and the framework of review for the national security, I think the panel should be praised for the very flexible and kind of very well-crafted framework of review, because on the one hand, panel gave kind of a wide discretion to the state which adopts the national security measure, because the panel said it's up to the state to define what it means under the essential security interest, which should be related to the emergency in international relations. But the state should do it in a good faith, like in respecting good faith obligation, which derives from Article 26 and 31 of the Vienna Convention. And on the second hand, the panel said that, you know, here we have also kind of objective elements. So there is a red line which a state cannot cross. And these objective elements, the panel said, are first, the situation of emergency in international relations or armed conflict. And the second is the timing coincidence of the measure and the situation of emergency in international relations. And here, again, it seems that it's a very kind of lenient on the one hand, because it provides a deference to states, but it's kind of very hardcore because the panel can review the situation of emergency of international relations and the timing element. But at the same time, we could see that it's a very well crafted because it allows a panel to accommodate future national security cases and to accommodate like new interpretation of the essential security issues. But I think that at the end of the day, we understand that this panel report was kind of a test case, and the panel, in order to create this flexible framework of review, distanced itself from the factual background of the case in order to provide like the framework for the future cases. So it seems that it sacrificed the solving of the specific case, but it was thinking about the future implications of this specific panel report.
Very briefly, I'll try to put this in a political context. Key questions, on the key questions. But let me say real quick that the way that the system is set up is vague, and that was particularly so. There is constructive ambiguity in a way, but at the same time, it's very clear. The issue here is that the rules, the WTO system, is about countries or actors that want to do trade with one another. So if I'm at war with Victoria here, obviously I'm not going to try to do that because we've got a terrible situation. So it's pretty clear cut, right? So that's why this case was particularly important. It was the first time whether or not the panel has jurisdiction to review a WTO member's invocation of security exceptions. Now, the problem comes in when a member starts capriciously applying national security to take measures. Where do you draw the line? Who answers that particular question? And obviously, from the legal part, now we've got some reference to shed some light on maybe future incidents. But there are now cases that involve countries that have political problems with one another and that they have started taking measures. That impacts the flow of trade. And once you start going down that road, there is no end to it. So the panel tried to understand that and shed some light on that particular issue. So in that sense, it was a landmark case, and the report said yes, it could actually look at whether or not it has jurisdiction over members' invocation to apply security exception. Second question was the characterization of security interest. Is it self-judging? A lot of countries, like mine, like the United States, they are very protective of their own sovereign rights. And the panel report says yes, but it also says there is a but to it, and it says that the discretion of the member that claims to take action for the protection of its essential security interests is not limitless. It was about what I just tried to clarify when I said a member capriciously using security exceptions because it is having certain political or other problems with another actor. If you open the door in a situation like that, the system will get hurt and it will crack. And this is something that we also talk about at the WTO. I was particularly interested, and my colleague who's sitting over there, our chief commercial counselor, pointed out yesterday when I was having a discussion with him that the Chinese proposal for the WTO reform included actually a reference to look into that question, which was very, very interesting. And I'm very curious as to how that idea is going to play out in the next coming months. Thank you.
point with regard to which Burak said with regard to the political issues. I think the panel very nicely said that actually in this case it doesn't matter who bears the international responsibility for the situation of emergency in international relations, and it's also not necessary to characterize the situation of emergency in international relations from the point of view of general international law. And I think this was kind of a signal that the panel said that, look, here we don't want states to use the WTO for bringing the political dispute. So it kind of it made a carve out with regard to the trade-related security disputes, but it said that you should not use it as a backdoor for bringing political disputes.
Great, thank you both so much. So staying on the trade law focus, I want to ask Nicholas to sort of zoom us out again a little bit more. Nicholas, you've done a lot of writing and thinking about this. How about starting with perhaps how we got here in trade law, and then maybe you can help us thereafter with where we go. So we'll get your slides up here with the help of our colleagues.
So as Kathleen said, I'm trying to zoom out, and I've been working for some time and now doing that with Anthea Roberts in an attempt to understand the different narratives that are at play in the current situation, the different narratives about winners and losers from globalization. And one of the difficulties with the policies adopted by the Trump administration is, of course, that they can be understood in different ways. And this is what I've tried to do here on the slide, is to just put some of these policies together in this Venn diagram and signal the different narratives that could be used to explain them. On top, we have the protectionist narrative, which is really the tariff man view, where there's this famous quote from Trump where he says, during his first year in office, where are my tariffs? Bring me my tariffs, because his staff was preventing him from implementing tariffs. At the bottom, on the left, we have the geoeconomic narrative that Enrique was describing, represented very much by Peter Navarro, this idea that economic security is national security. And here on the bottom right, we have what we call the establishment narrative, which is this idea that globalization is basically good. But even from the perspective of the establishment narrative, some of these measures might be justifiable because they could be used as leverage to transform China's non-market policies and so essentially to achieve further liberalization. And so the really interesting measures are the ones that are in the overlapping sections. So, for example, the Section 232 measures on steel, aluminum, and autos, they can be seen as both from a national security perspective, as necessary for the national security, which is, of course, the US justification. But virtually all the US trading partners see them, and actually many in US Congress, see them as purely protectionist, right? And so they have reacted accordingly. They haven't accepted the US national security justification. So in that case, the fact that there's this overlap has actually been a point of contention, a point of controversy, because you can interpret the same measures from different views, and the US and its trading partners have different views of what the point of these measures is. In the case of Section 301 tariffs on China, interestingly, the overlap signifies something different. It signifies that there's actually quite a bit of support, because countries support these measures, or not countries, but actors in the US support these measures for different reasons. Trump may just be after protection, right? So after the talks with China broke down, there were actually articles in the New York Times and in Bloomberg which said that, oh, maybe this whole thing wasn't about leverage, maybe it was just about tariffs. Whereas, of course, others in the US Congress and also perhaps internationally support these tariffs as a way of putting pressure on China to change some of the practices that Enrique talked about. And finally, adding Huawei to the entity list was, of course, justified on national security grounds, but Trump has again brought up the possibility that this might become a bargaining chip in the conversation with China. So I think the big question going forward is going to be which of these perspectives is going to prevail in the US, which perspective are we going to adopt? If most of these measures are really adopted for protectionist reasons and seen as being adopted for protectionist reasons, there's some hope that this whole episode is going to be seen as an aberration, because once Trump is gone, there's a good chance that they're going to be abandoned. I think that's the most likely scenario for the Section 232 measures, because there's not a lot of support, as far as I can tell, in the US for these measures, or for adopting these measures purely for protectionist reasons. If the predominant view going forward is going to be that, yes, these measures are useful as leverage towards China, then there's hope that once some kind of accommodation is reached with China, that these measures are going to go away again. I think and so once this accommodation is reached, we'll have, can maybe return to some kind of normalcy. I think the game changes really if the interpretation of these measures as necessary for national security reasons, if that prevails. Then we really, I think, are facing something akin to a new order where the aim is or it becomes necessary to decouple essentially the US economy from China. And so I think the most significant measure in that regard is really the action was taken against Huawei, which essentially says we can't let foreign companies under the control or jurisdiction of a foreign adversary anywhere into our supply chain. And as we just heard from Richard Baldwin, data is going into every aspect of the economy, which means essentially if you want to keep a foreign adversary out of everything that involves data, then you have to keep the foreign adversary completely out of your economy. And so we are facing a scenario where the international economic order as we know it breaks down. But I'm hopeful, I mean, the jury is still out, and I'm hopeful that hopefully one of those more positive outcomes will prevail.
Well, with those competing narratives, thoughts, though, Nicholas, on how we might move forward, despite not knowing which might prevail?
So that, of course, raises the question, what's the role of the international trade regime in this? And I've just put up here the different dispute resolution outcomes that we can achieve in the WTO. And the preference in the DSU is clearly for a negotiated solution that is acceptable for the parties. Of course, there's the hope that such a resolution might actually embody a higher level of concessions than the status quo ante. If that's not possible, the default is simply compliance. Again, if compliance can't be achieved, then where the DSU looks for compensation, which at least preserves the level of concession, the balance of concessions, even though it's not the same, the balance in the level of concession, even though it's not the same concessions as originally negotiated. And so the fallback option really is rebalancing, where you lose the level of concession but preserve the balance of concession at the very least. And so in thinking about how these disputes are currently playing out partly or outside the remit of the trade regime could be brought back into the regime, I think we have to start at the very lower end, because it's the least demanding in terms of cooperation that it demands from the participants. And so I just wanted to take you to some of the options about how this rebalancing could be achieved in the case of national security measures. So if we're facing a genuine emergency in international relations, then rebalancing of concessions can happen under Article 21 itself. We just heard from the previous speakers that it doesn't matter who caused the international emergency. Essentially, if there's an emergency between two countries, arguably both countries enjoy wide discretion which kind of measures they consider necessary to preserve their interests. So rebalancing could actually happen under Article 21. If there's no genuine emergency in international relations, arguably the use of national security measures is probably going to be illegal, but I don't think there's much point to bringing a violation claim against those measures in the WTO, because no self-respecting country is going to withdraw those measures if they said that it's for some national security reasons just because there's a panel or WTO ruling. So really the issue is rebalancing. That's the best you can hope to achieve, and if that's the best you can hope to achieve, why not go straight for a non-violation claim where you're not contesting the legality of the measure, but are saying that benefits that you were expecting have been nullified or impaired by the measure. And in fact, the US has, in its own submissions, been open to this reading that non-violation claims remain available for national security measures. Just two quick points to finish. Proposals for what else could be done. Simon Lester and Han So have proposed rebalancing on the safeguards model, where you would be allowed to rebalance like you are when another member adopts safeguards. They envisage that there would be procedural safeguards and there would be multilateral supervision of that. But the model that is, I think, really prevailing now when we look at the negotiations that have been happening with Canada in the US, Mexico in the US, is something that's modeled on the NAFTA cultural exception. Those of you who don't know the NAFTA cultural exception, it's in the originally Canada-US Free Trade Agreement incorporated by reference into NAFTA. It says that Canada can adopt virtually any measure it considers it wants with regard to cultural industries. In fact, it exempts cultural industries from the agreement, but then allows the US to suspend commercially equivalent concessions where Canada adopts such measures. And you see, what's interesting about this is there's no review, no notification requirement. It's essentially an automatic right to rebalance, which could presumably be subject to post hoc review. But that's very much what is also reflected in the agreements that Canada adopted with the US to settle essentially the 232 measures on steel and aluminum. There, Canada and the US virtually accept that Canada is going to retaliate again if the US reimposes the measures. And the only suggestion I have going forward is that when countries negotiate now for new free trade agreements, that they incorporate this right for automatic rebalancing in their free trade agreements so that the whole dynamic of imposition of national security measures and retaliation can be brought within the legal framework of the trade regime.
Okay, a lot to consider there. Thanks, Nicholas. There's already been some recasting, of course, in the area of export control. And so with that, we'll turn to Cindy. Cindy, what's happening in the export control space, and how does that fit together with the trends that our colleagues have identified here in other spaces?
So export control are domestic regulations that really restrict outbound trade based on, for goods and technology, generally based on national security concerns, but also for foreign policy concerns. So for the United States, I'm going to use this United States specifically because of the new law that has been passed. But for the United States, has been a strong proponent of establishing export control regulations like the one that Nicholas just said that listed Huawei as the entity list. That's part of the export control in the United States. And it has also been strongly, they're also strongly asked their partners, trading partners, to also impose export controls. And besides domestic regulations in the international realm, the United States has also been a strong proponent of establishing international export control regimes to create a unified front to prevent the proliferation of weapons of mass destruction and during the Cold War, restrain certain dual use or military use technologies from being moved to the Soviet Union. So that has been sort of the structure of export control. But because export control is so actually closely tied with a lot of foreign policy concerns and national security concerns, international export control regimes, by and large, are largely unofficial and have been run on a basis of consensus. And participating states then would, through the consensus, the list that formed through consensus, adopt these lists in their domestic export control regulations and have the discretion of adopting the list. And so that has sort of been the structure of export control. What the panel has been talking about is sort of the broadening of the inclusion of economic security into this, into the narrative of national security. And this is specifically important, or specifically quite clear, as we see last year, the United States passed the Export Control Reform Act of 2018. And there's two specific things in the Export Control Reform Act that I want to specifically talk about, and as it compares with its predecessor, the Export Administration Act of 1979, that sort of highlights this expanding scope of including economic concerns, economic security as sort of a national security concern. The first is sort of the consolidation of what used to be two separate lists, which are the national security controls and also the foreign policy controls. And the second thing, the second challenge, the second change that has emerged is this new list called this Emerging and Foundational Technology list that the United States now want to control. So going back to the first change of this national security control, the consolidation of national security controls and foreign policy controls, the reason why this is important is if you go back and look at the predecessor, the Export Administration Act, national security control is actually very closely aligned with international export control regimes. So the United States has actually, in the statute, refrained itself from unilaterally applying export controls if it relates to national security concerns. But if you look at the foreign policy controls, it's slightly different because it is based on the United States foreign policy, so it could be applied unilaterally. In the new statute that was passed last year, in order to streamline these controls, these national security controls and foreign policy controls are sort of lumped together and discussed on the same basis. And what is unclear is what it means for the cooperation or the relationship between the multilateral regimes for export control and what it would mean for the United States if it should or could apply unilaterally export controls on certain goods. And which leads to the second important thing, which was a change in the statute, which was the new category of emerging and foundational technology that the United States now wants to control, which is in Section 1758 of the Export Control Reform Act. Inside, the United States makes it very clear, sort of going back to what Nicholas and what the previous panelists have said, that the United States view the leadership, their leadership in both industry and technology to be somewhat very important, and therefore they want to impose export control on the so-called emerging and foundational technologies. Now, the statute itself is not clear in what the criteria of emerging or foundational technologies are, but in November of last year, the United States Department of Commerce, Bureau of Industry and Security has actually proposed 14 different technologies that they want to list it under emerging technologies. And to give everybody a flavor of what these technologies are, these are biotechnology, artificial intelligence, 3D printing, and surveillance technology, and so on and so forth. So it's very broad in scope and quite I would say, not really specific in its contents. And so the industry feedback and the comments has been along the lines of hoping that the United States would actually contain itself with this new list of emerging technologies, to contain it so that it would still fit into the original description of a more traditional national security scope of it being related to military use goods. But I think what the trend is and what the United States is doing, I don't think that that's what is going to happen. And I think that as for export control, I think that's sort of a reflection of how, or that's sort of a reflection, or you could see that this is actually an area of law where this economic security national security is really being played out.
So a lot to think about there, and you brought us back also to the idea of the place of industry as we see these things playing out, so that's something maybe we could come back to. But for now, Cindy, just projecting sort of forward, what lessons do we take away from all of these different reform efforts, as well as these developments within the Commerce Department and elsewhere? What lessons for the export control regime?
I think for the export control regime, it has been built up since the end of World War II. And because its relationship with national security and foreign policy controls, there has been a lot of up and downs in the international arena in trying to negotiate the list and establish currently what is sort of the status quo of these unofficial international export control regimes, but these lists that actually most countries actually do follow. And what we see here is, I would actually call it a disruption of what has been slowly built after World War II, and this integration of economic security into national security, causing some disruption on what we would probably call the norm, or what people would consider to be the norm of how things have been structured, have been run.
All right, well, we need to now add to this buffet, and I hope you all are thinking, we're shortly coming to you, so be thinking about what you're going to take from the buffet and ask to our guests here. But we have to add, critically, the latest developments in investment law, and put that on the table here as well. The regulation of foreign investments, thinking about how they fit in more broadly in this discussion. So for that, we turn to Ted to tell us really whether these trends are also occurring in investment. Are we seeing the same, and are these particularly recent or new developments? Let's start with that.
Great. Well, thank you, Kathleen. The short answer is yes. The trends that other members of the panel have surfaced certainly are showing themselves in the investment arena as well. The common theme here being this expanding notion of what we mean when we talk about national security, and where this conversation is really finding its epicenter is in the law concerning what's known as the Committee on Foreign Investment in the United States, or as we more commonly refer to it, CFIUS, which is not a disease. It is the unfortunate acronym for this committee. I'll say a brief word about what CFIUS is, what it had been up until very recently, and the trends as of really just about a year ago. There's actually, some of you may have it, a little slide, or actually 4 slides that Teresa very kindly printed on a page for anyone who wants a short guide to CFIUS and what it's all about. Briefly, the CFIUS saga began back in the mid-1970s in the Ford administration, at a time when the stock of foreign direct investment in the United States was tiny, negligible, compared to what it is today. But it was beginning to grow, and there was a thought that the United States should at least start studying foreign direct investment in the United States to get a sense of its impact in various areas of policy. So a study group was formed, chaired by the Secretary of the Treasury, to examine and look at trends in foreign direct investment in the United States. Fast forward to the late 1980s. In 1988, the US Congress enacts the Omnibus Trade Act of 1988, which many here know for other aspects of it, including the fast-track provisions relating to the setting of US trade policy. But one other provision in that act was the so-called Exxon Florio Amendment, which took what had been a study group and actually invested the president with certain powers, which he then delegated to CFIUS. So starting in 1988, the US president is authorized to suspend or block certain investments in the United States, certain foreign investments in the United States, if he determines that that investment would jeopardize US national security. And this authority is given to the president. The president then says there's this existing committee that we can delegate the investigative task to. So CFIUS is now delegated with the job of examining foreign investment in the United States and determining what impact it has on national security. And if it's determined to impair US national security, then to recommend to the president that he either block it if it hasn't yet occurred, or order divestment if it already has occurred. And in the early days, it was an interesting new development. There actually was one Chinese transaction blocked in the very early years of CFIUS in 1990 by the first President Bush. But a transaction in an area very centrally connected to what I think lay people would commonly consider to be in sort of the heartland of national security. And through the late 1980s into the early 1990s, there was a concern at the time primarily about Japanese investment in the United States and the rise of Japanese investment in the United States, but really not a lot of activity in the world of CFIUS. The way that risks associated with inbound investment were conceptualized pretty much accorded with conventional notions of what constitutes national security. Fast forward to September 11th, 2001, and the tragedy of that day and everything that followed in its aftermath. Now the United States begins to look at national security in a much more expansive way. You have the creation of the Department of Homeland Security, an agency that hadn't existed before, which is given a mandate when it comes to national security in the United States. Fast forward a few years after September 11th, you have the famous or infamous Dubai Ports World transaction, in which Dubai Ports World acquires the Peninsular and Oriental Company, a company that's responsible for port operations around the world. Members of this transaction is notified to CFIUS. CFIUS clears it, finds no impairment of national security, but the U.S. Congress gets very concerned and starts focusing on the fact that that ports are vulnerable places, that a bad actor with control over the operations of a port could exploit that control. And Congress becomes very critical of the fact that CFIUS allowed this transaction to be cleared. And so you really have this growing debate over how that happens, and Congress acts by adopting new legislation called the Foreign Investment and National Security Act of 2007, the upshot of which is to sort of formalize the expanded notion of national security. So now we look at ports, we look at infrastructure, we look at other kinds of investment beyond, armaments and conventional notions of national security as potentially impairing national security. Fast forward to today and last year, and the same piece of legislation that Cindy was referring to that included the Export Reform Act of 2018, that very same piece of legislation includes the Foreign Investment Risk Review Modernization Act, or FIRMA, which widely expands what CFIUS does. It expressly now embeds the notion that investments that involve what are called critical technologies, which is linked to emerging and foundational technologies, investments in critical infrastructure, investments involving information, access to information, can jeopardize national security. And not only does it expand the categories of what's encompassed by national security, it also says to CFIUS, you now have the power to review not only transactions in which a foreign person will obtain control of a U.S. business, you also have the authority to review certain transactions where the stake obtained by the foreign investor is short of control. And you even have the power in certain cases to review so-called greenfield investments where a foreign person is acquiring real estate, just bare unimproved real estate, if that's in close proximity to sites that the United States sees as sensitive. So we are about to enter an era. FIRMA was adopted last August. A small piece of it was rolled out in November concerning so-called critical technologies. Later this year or early next year, we'll see the full-blown rollout, and we'll see a vastly expanded approach to the way the United States reviews inbound investment.
Ted, can I ask you also just to say a bit about also the sanctions area, which of course Treasury also manages, CFIUS also manages the sanctions program.
Sure. So a different part of Treasury, but we're seeing some of the same themes emerge. I mean, I think one of the interesting things here, going to Nicholas's slide, is that, we see the same sort of thing emerging with CFIUS, with Section 232, now with the possible use of the International Emergency Economic Powers Act, IEPA, as a justification for imposing tariffs on goods from Mexico if Mexico doesn't do its part in solving the immigration crisis at the southern border, and in the sanctions area, an increasing use of economic policy tools to accomplish some ostensible national security end. So in the sanctions area, we're seeing a number of different trends. we're seeing an increasing use of so-called secondary sanctions. So most of the sanctions that the United States imposes are sanctions directed towards U.S. persons. It tells U.S. persons what they can and can't do. You can't engage in transactions with persons in Iran. You can't engage in transactions with so-called specially designated nationals. Primarily addressed to U.S. persons. When we talk about secondary sanctions, essentially we're talking about sanctions with extraterritorial effect. So now the directive goes out not to just U.S. persons, but to non-U.S. persons. So last year, when the United States withdrew from the Joint Comprehensive Plan of Action, the so-called Iran nuclear deal, one of the consequences of that was that non-U.S. subsidiaries of U.S. companies became subject to the same restrictions as the parent company itself. So if you are a German subsidiary of a US company, you are now subject to the same prohibitions on dealings with Iran as the US company. You have an even more expansive use of secondary sanctions where there's no real nexus to the United States when it comes, for example, to purchasing petroleum and petroleum products from Iran. Many of you probably recall a few weeks ago, the Secretary of State announced that, that the United States will no longer allow China and India and other major purchasers of petroleum products from Iran to engage in those purchases. And what can we do about it if they do? Well, they lose access to the U.S. market, they lose access to the U.S. financial system, they lose access, they lose the ability to participate in tenders for U.S. government contracts and export-import support and the like. Not only are we seeing the reach of the law as prescribed extending in this way, we're also seeing the Office of Foreign Assets Control, which is the Treasury Department office that enforces these laws, exercise its enforcement powers vigorously. In the past, if you'd heard about OFAC, it was probably in the context of sanctions imposed with respect to financial institutions. So every so often, you'll hear about a major fine being imposed on a bank that allowed customers to use its system to engage in transactions with sanctions persons that the bank shouldn't have allowed. So the focus was primarily financial institutions. In the first quarter of this year, just in the first 3 months of 2019, we've seen, I think it's now 10 enforcement actions by OFAC, most of which are addressed to non-financial institutions, industrial companies, some of which you've probably heard of. So for example, Stanley Black & Decker, the home tools manufacturer, was fined because of the actions of an affiliate in China that continued to do business with Iran post-acquisition by Stanley Black & Decker. So we're seeing an increasing focus by OFAC on exactly these kinds of issues of activities by non-U.S. parties.
And so then just lastly, Ted, I know you've been giving a lot of thought to these developments, and so you have some recommendations for policymakers on how we might do these differently?
So I don't know if they're recommendations, but I would say it's the early germs of an idea, and it's this. I think that a theme running throughout really all of the comments today is that back when Article 21 was drafted, back when the predecessor to Section 232 was being drafted, you see policymakers really wrestling with the things that have now come out in the open today about how do you reconcile the need to have a relatively free hand when it comes to national security with the desire to be a part of a rule-bound system. How do you do that? And they struggled with it. There was a lot of hand-wringing, but I think at the end of the day, policymakers sort of reconciled themselves with the idea that responsible leaders would exercise restraint and that they had a common notion. Even if they couldn't articulate what national security means, there was sort of this sense that we all understand it. It's like Justice Potter Stewart's famous dictum about pornography. I know it when I see it. Likewise, with respect to national security, I know it when I see it. I understand what it means. And that largely prevailed for the past several decades. Now, with changes in technology, with an erosion of that restraint and a willingness to use tools like Section 232, like IEPA for, as a trade tool. We're seeing an erosion of restraint and an expansion of the understanding or the conceptualization of national security. So I think we may be at a moment where at least it's worth thinking about developing some common principles, not hard law, not an agreement, not a common definition of national security, but at least soft principles of sort of what the core elements of national security here. The precedent I'm thinking of, the model is a number of years ago, a little over a decade ago, when the big concern when it came to national security and foreign investment was the rise of sovereign wealth funds. You had the Santiago principles and the corresponding exercise within the IMF to identify sort of some guidelines for how sovereign wealth funds would go about investment. I think we may be at a moment where it's at least worth thinking about, can we develop some shared understanding of what we mean when we talk about national security, not as a binding rule, not as an agreement, not as law, but just as as sort of soft guidelines to help us think about it as we enter this bold new era.
Terrific. Thank you. Well, you all have been very patient, and I see friendly, thoughtful faces that suggest you have questions and comments that you would like to contribute. So I would like to switch to that. We have a number of proposals, critiques, observations on the table. As I said, it's quite the buffet. So our magical microphone movers will come to you. We're going to collect a number of questions. So we'll start here with this gentleman, and then I see one in the back, and then also one. Okay, we'll start. Please introduce yourself.
My name is James Flett. I work for the European Commission Legal Service, and I am, from time to time, involved in litigation. A very interesting panel. We do actually have a provision, Article 21, and I'd like to hear the panel's views on 3 points. Is 21 available for violations of agreements other than the GATT, such as, for example, the Safeguards Agreement? Second, if you're looking at a single indivisible measure, and I emphasize a single indivisible measure, which is partly or even mostly covered by Article 21, but not entirely, does the defense fail? And third, in a security of supply case, if the facts demonstrate that the well-being of the domestic industry is an end in itself, as opposed to a means to an end, which would be the security objective, does the defense fail?
Thank you. Okay, since we're clumped there, to your left, Florencia, and then, yes, thank you.
Thank you very much. Sherzad Chedhajayev from the KDI School of Public Policy Management, South Korea. I have a question regarding the panel's finding that, it is irrelevant to consider who is responsible for creating an emergency situation in order to see whether Article 21 could be invoked or not. Whereas I fully understand that for how panels are reluctant to consider that issue. On the other hand, do you think that it may create a situation when the countries may themselves be incentivized to create certain kind of emergency situation first, and then invoke any trade restrictions against the other side? Thank you.
Thank you. And then also just there, thank you.
Henry Gao from Singapore Management University. I want to ask a question to Nick. Your 3 different diagrams are very interesting, but I was puzzled as to whether we could really apply the non-violation complaint to the cases of national measures taken on national security grounds, because here you have a clear violation of several GATT principles like MFN, like tariff banning provision, and I guess that is not how normally we would use the non-violation complaint for, because for non-violation complaint to work, you would need to assume that the measure actually doesn't violate any existing GATT provisions, but there are clear violations. So I would like you to please elaborate on how it will work. Thank you.
We're going to take one more with this round, and then rest assured I'll come back to you, but this one is at the very back, and we have another microphone there. Thank you.
Hi, I'm the editorial assistant for the Journal of International Economic Law, and also a PhD candidate at KU Leuven. My name is Vineet. My question is on the language of GATT Article 21 itself. Now, amending the GATT is a tedious process, I know, but you see that same language in also bilateral and multilateral investment treaties, which sort of has more governmental control in renegotiation. So if certain countries who are not, who do not appreciate the panel's ruling on the justiciability aspect of it, do you see or predict a trend in amending the investment treaties on those issues and moving forward on investment levels, barring the CIFUS element, that is?
Okay, so we need a complete legal analysis of certain, we'll do our best with those very difficult questions. Who would like to begin? Nicholas?
On the non-violation question, so you're absolutely right. If you look at the violation of the provisions in isolation, there would be clearly a violation. But if you look at it together with the exception, and especially given the expansive reading that the panel has given to the exception, there's a real question to what extent any measure that at least, where there is at least some kind of emergency, would be in violation of WTO law, taking the GATT provisions and the exceptions together. But my argument is not so much about using non-violation claims only where there's where it's kind of in question whether there's a violation. It's more about the political context. You could make a political choice as a complainant to bring a non-violation claim in the case of a national security measure, because of course the national security measures are always politically sensitive. And so if you bring a violation claim, you're essentially questioning the members who has a judgment as to its own national security interests, impliedly. So in that is something that I think countries should be reluctant to do, because it's obviously national security is an important sovereign right. On the other hand, you also don't want to open the floodgates, right? If you said you were never going to challenge national security measures, then members could adopt any measures and get away with it. And so the idea of using non-violation claims is a way to avoid both of these problems. You're not really questioning the other member's judgment as to its national security interests. On the other hand, you're saying here, benefits that I was reasonably anticipating to receive have been nullified or impaired. And therefore, I want to get compensation, or if you're not willing to give me compensation, I want the right to suspend concessions. There is a problem with this argument, which is that under Article 26, the panel actually has to find that there's a measure which does not violate the agreements. So the panel will not get completely around pronouncing itself on the legality of the measure. I'm just wondering to what extent the panel would really engage in that analysis or probe very deeply if both parties essentially agree that there's no violation. If the complainant says, I'm not saying there's a violation, the respondent will of course say there's no violation. I wonder to what extent the panel would really then conduct its own analysis. But the idea is, if the ultimate objective is rebalancing, if it's not realistic to expect that the member will withdraw the measure just because there's a panel appellate ruling saying it's illegal, then why not go straight for what you're really aiming for, which is to get compensation or to get the right to rebalance. And you could even it would even quicken the proceedings, because under the DSU, in the case of non-violation claims, the Article 21.3c panel can actually find what the degree of the amount of nullification or impairment is. So you could essentially take some shortcuts and then get the same rights to retaliate that you would get under if you had brought a violation claim. I don't know whether that answers your question, but it's really more a question of litigation strategy than a purely legal question.
Okay, now some challenging other questions as well. Shall we pass? Yep, go ahead. Victoria, yep.
So with regard to the first question, with regard to whether the GATT Article 21 is available for the justification of violation of other agreements than GATT. And I think it was already discussed among scholars whether we can justify safeguards measures under the GATT Article 21. And I think here we should think in terms of, for example, the connection between the agreement which is violated. For example, we have GATT Article 19, which is on safeguards, and then we have the safeguards agreement. And here we have the connection which, for example, the appellate body interpreted in China raw materials when China was trying to justify the violation under the protocol of accession. So here it should be the connection between the agreement and the GATT Article 21. And I think, for example, safeguards violation you can justify under the GATT Article 21 because the safeguards agreement is like the clarification and like was born out of the GATT Article 19. Then the second question was with regard to the single indivisible measure when it has kind of double aim, for example, I don't know, kind of safeguard measure and protection of essential security. Here, again, I think the kind of very similar case was EC seals, when we had like the aim of protection of public morals and kind of also the exhaustible natural resources. And here I think like the panel should differentiate between these two different aims and characteristics of the measure and separate them and see like whether we can basically kind of justify for example, the specific national security characteristic under the GATT Article 21. And also, it doesn't mean that, for example, if there is no justification under the, let's say, safeguards agreement, that it kind of works in disfavor of justifying under the GATT Article 21. So the panel should differentiate and assess them like separately. And the third question,
maybe we'll hold the third question for the coffee hour.
Should I reply?
No, if you go on if you wish, but we can also, if others want to jump in on either the bits or the create incentive of emergency.
Well, just the point there, the question that the last questioner raised about you know, trends in negotiation of essential security clause in the wake of the Ukraine-Russia decision. I mean, in fact, certainly for the United States, this was a trend that we were seeing already, long before this dispute ever emerged. So in all of its post-NAFTA free trade agreements and BITs, the United States has dispensed with the Article 21 formulation for essential security, so you don't have the subparagraphs under 21B. You just have the considers necessary for its essential security interests. And in fact, in at least a couple of the more recent free trade agreements and BITs, you have negotiators going even further and directing a panel or tribunal that's hearing a case where the essential security defense is invoked to immediately terminate the case. So there's, you know, a real effort to be very clear on the self-judging nature of that defense.
Okay, let's go back out to you all, and don't be shy. I saw a hand over here that I couldn't quite get before, so there's one here. Then we're going to go over here, and again, be confident with, and then we'll go down there. Great. Wave wildly if I missed you.
Thank you. I'm Po Chin Lee. I'm the legal advisor of the Chinese Taipei mission to the WTO. My question is also about the Russia and Ukraine case, the good fast approach used by the panel in that case. It seems that the panel established its jurisdiction to review the relevance between the Russia measure and the emergency situation based on this good faith principle. My problem is, do you think that this legal base is a little bit fragile? And on the other hand, if the good faith principle could be used like this way, then WTO adjudicators can actually introduce any element that it deems of good faith nature in any provision, in any WTO provisions without any textual basis. So, thank you.
Thank you. Yes, here.
Sergey Tima, WTO Expertise Center, Russia. My question will be to Nicholas on non-violation complaint. As I see from Article 26 of the ECU, actually what the panels and appellate body can do on the 21.3, they can suggest ways to find mutually satisfied adjustment. And mutually satisfied adjustment means that both parties shall agree what could be the ways of compensation or suspension. And taking this into account, don't you think that non-violation complaint, when it turns to the implementation stage, is not a very good way to solve the problem? Thank you.
Thank you. Looking again over here. Okay, then we'll go to Joost. Oh, sorry, there was some here. Pardon. Thank you very much. One over here. Pardon me. Yes, just here. Thank you.
Thank you. My name is Yusong Chen from the Mission of China to the WTO, and I would like to have probably one comment and two questions. And one comment is regarding so-called asymmetrics, between the U.S.-China trade. And in this regard, I would like to encourage the panelists to read another report just published by MOFCOM regarding how much the United States has gained from this bilateral trade. And it seems to me that though China have big trade surplus, to the United States, but a lot of them from other countries like Japan or South Korea and assembled in China and then export to the United States. And also, the benefit of this bilateral trade seems also going back to the United States. So a lot of money have been moved back to the United States. So probably my comment is that we should not probably focus on the trade surplus only, but have much bigger picture of the who gained from this bilateral trade. And two questions, and first go to Nicholas. And I've been quite impressed by your picture on how we can rebalance the system. But when we are talking about rebalance, so I would like to question, so where's the starting point of balance? So what do you mean of balance? Do you think a trade surplus is a kind of imbalance, and the trade surplus is unfair trade? So what is the ultimate purpose of this world trading regime? So shall we establish a regime that, so there will be no surplus of everyone? So that is our purpose? So this is our question. And another question to Mr. Mr. Posner? Yeah. And you just mentioned that there should be probably some principles about national security. I'm quite interested in that. So probably in your mind, and we could see from the panel in 512 that the panel said that there should be a principle of good faith. In implementing national security reasons. So, what in your mind? So maybe other principles, just like proportionality or such a kind of other principles, should be included. In those principles as you imagine. Thank you.
Fabulous. And here to Joost, final question.
Wonderful discussion. Really, I enjoyed it. A couple of quick questions. You all focused, when it comes to Article 21, on the sub-paragraph on war and emergency in international relations. I'd like to hear from anyone who has an idea on this. What do you think the panel report means for the other prong, which refers to, I don't have the text here, but supply of military establishment directly, indirectly, which, if anything, seems to cover a lot of things. And many of the things you were like Ted was referring to, outside of the traditional definition of national security. So if I read the panel, war and emergency in international relations, it's pretty relatively limited compared to all the things you mentioned. Secondly, I'd like to know, especially from Brazil, Turkey, because many of you mentioned the slippery slope, like what will happen if we start doing national security for many of these different things. But I kept hearing examples from the US. And I know in the EU they have an investment screening policy. The slippery slope, is it already happening that other countries are kind of going in the same direction? Brazil, Turkey. I'm not thinking of the Qatar case, Venezuela, but the kind of the new developments. And finally, for Nicholas, the Venn diagram you had is amazing, really very instructive. I noticed though that you don't have anything in the very middle. And yet, to me, it seems, thinking of a solution, that's probably where one will have to go. Settling on some tariffs, buying some more soybeans, national security, some kind of decoupling, and then perhaps rebalance where, you know, China can change certain elements of its model. The US has national security, and then perhaps have a 25% tariff to calculate the value of those unchangeable conditions. So what's in the middle of the Venn diagram for you?
Okay, this time I think we'll go this way and invite if there are any other comments that anyone wanted to make in response to other things that have been said, but we only have a short time, so please, if we could be brief.
I just wanted to make two comments. One, in response to the question of if I were developing a list of principles, what do I have in mind? So you referred to things like proportionality and good faith. I'm talking about principles to guide not the kinds of measures a member could take, but what is national security? And so, you know, certainly you would start with the core of what's commonly understood. You would probably expand out from there. To be honest, I haven't given a lot of thought how far out you would expand, but that's what I had in mind generally. To the slippery slope point that Joost asks about, I think there is one ray of hope here, which is that you know, there are mechanisms that you know, put roadblocks along that slippery slope. So in the United States, you know, in response to some of these novel invocations of national security, we're starting to see some rumblings within the U.S. Congress that could lead to new legislation to forestall the use of some of these measures. So there's been discussion, particularly in the U.S. Senate, around legislation that would require an act of Congress in order to continue any tariffs put in place in the name of national security, which suggests that, you know, within a given system, if you go too far, there may be, you know, safeguards to prevent you from going all the way down that slope.
With regard to the good faith obligation, right, I think the panel was kind of very flexible. So good faith seems to be a very kind of vague and obviously like it stems from, as I said, Article 26 and 31 of the Vienna Convention. But I think here the panel kind of limited also the broad interpretation by saying that basically the essential security interests depend on the situation of emergency, and since in this case it was a hardcore emergency, emergency in international relations, it was enough for Russia to minimally like satisfy this benchmark. But I think in other cases the panel will be kind of more demanding in terms of good faith obligation if, for example, the situation would be not that grave as in the case of Russia and Ukraine. So it's vague, but at the same time, it depends on other elements.
Thank you. I just wanted to address Joost's questions on the slippery slope. One of the reasons that people keep talking about that is that a number of countries got hit with 232 measures, and all of them responded within the system through the safeguard agreement violation and so on. Then there came Hawaii. Then there came, other measures like the recent ones on Mexico. And the examples can go on. Clearly, there is a trend here, a political leaning, a political choice. So how do you deal with that? That is a key question. And that also has to do with the good faith question. As I said at the beginning, the system and the rules are for everyone, but also for those, especially for those who actually want to do trade with one another. So if you've got a problem with me and those problems are getting bigger and bigger and may translate into all-out, conflict, obviously, these rules will be set aside in terms of trade. On the supply of military situation, that's a serious one. And if you're sitting with someone across the table and then they're telling you that, hey, your country is supplying this and this and that to country so and so, and that I'm having a serious problem with that particular country with a potential conflict, physical conflict, then you have a serious problem, and then you think about that. But the key question is, again, goes to good faith. If you know that you're being told that on a shaky ground or based on a real, genuine concern. So in that sense, it's always up to the countries in a way. But panelists and others keep talking about the United States for two reasons. There is a political leaning, but also it has impact. I mean, suppose a small or medium-sized economy taking measures to a specific country, you could talk about that, and but the impact will be limited. But it's not the case with respect to the United States. Obviously, a lot of these discussions will be subordinate to the conclusion of US-China trade deal and other matters, including how the EU is going to be approaching to that. But the longer that lasts, and the more measures come into play for one reason or another, the worse it'll get for the multilateral trading system. And that is what a lot of medium-sized, developed or developing countries are particularly concerned about. So that good faith issue is vague, but at the same time, it is pretty clear. Thank you.
Just quickly on 3 points. So the first one was the question about Article 26 and non-violation claims. So Article 26 says explicitly where there's a non-violation claim, the procedures of this understanding shall apply, subject to certain modifications which relate also to Article 22. And so Article 22 also refers explicitly to situations where a recommendation has not been complied with, even if there's no issue of compliance. So, and that recommendation could presumably be a recommendation from the appellate body or panel that the member make a mutually satisfactory adjustment. And so if the member doesn't make that adjustment, then the provisions of Article 22 would apply. On the question of balance, what does balance mean? Well, there's a legal meaning and then there's a political meaning, right? So the legal meaning is simply the balance of concessions embodied in the agreements, which is the yardstick for rebalancing, because you can only suspend concessions to the extent of the nullification or impairment. But of course, there's a much bigger question whether the agreements are balanced, which is something that has been hampering the negotiations for a long time. And to your point that there's nothing in the middle, I think that's simply reflection. I couldn't find any like master policy that the Trump administration has developed which would address all these concerns. So, and if they had to come up with one, it would probably be a negotiation for some kind of grand bargain which would take care of all of these concerns, which would be presumably reduce the role of the Chinese state in this system and thereby alleviating some concerns about national security, at the same time maybe opening up the economy more so it would alleviate the trade deficit to some extent, taking care of some of the protectionist concerns, and of course it would also, if that bargain was achieved, there would be no reason to have additional leverage against China. So I'm still waiting for Bob Lighthizer to come up with that. policy.
Yeah. Thanks. Just to comment on and react on Jost's point about Brazil. I hope you're satisfied with my personal opinion instead of the position of Brazil. But I would just like to say that I think the trend that we see, of course, it's still unfolding, and much of the what the result will be or how things will turn out in the future will depend on the capacity of other states to push back or to react, and also of private actors, for example. And I think our colleague from China mentioned that in this interdependent world there were winners on both sides, and that's true. And so there are a lot of interests at stake that will have the capacity to somehow, I think, reshape how this debate will play out. One last point that I think is interesting, and picking up on the point that Nick was mentioning about this grand bargain, I think it's quite telling that most of the questions here were about the interpretation of Article 21 or the legal implications, but I think most of what's happening is outside of Article 21 or interpretation of Article 21, and it gives hope because I think it shows that there might be a possibility to negotiate some solution, hopefully. At the same time, it's something that we should be following, but leaving our comfort zone of just covering the legal rule, the black letter rule, and the interpretations. And I think it's quite telling that we tend, I think, to focus on what the rule says, how it is interpreted, when there's so much going on outside of or beyond this, and that's where we should be also focusing. Thank you.
Great, thank you so much. So on behalf of the 7 of us up here, again, we want to thank Joost and Chris, the Graduate Institute, and Georgetown, and their very able teams that have put this together. We want to thank all of you for your very thoughtful questions and your engagement on the subject matter. If we didn't get to you, I'm sorry, but the good news is we're just getting started, and there's coffee. So please join me in thanking our distinguished guests.